For decades, the United States Patent and Trademark Office granted gene patents, or patents for isolated DNA sequences representing genes. Such patents were controversial because they effectively granted patent holders exclusive rights to control how the relevant genes were used in clinical testing and scientific research. The United States Supreme Court assessed the validity of gene patents in Association for Molecular Pathology versus Myriad Genetics, Incorporated. Myriad Genetics discovered the location and DNA sequence of the BRCA1 and BRCA2 genes. Because mutations to those genes greatly increased a woman's risk of breast and ovarian cancer, locating the genes allowed for testing to identify women with an increased cancer risk. After its discoveries, Myriad obtained numerous patents. The patents included protection for the isolated DNA sequences of the BRCA genes and for complementary DNA, or cDNA, which was a lab-generated synthetic creation including only the portions of the DNA segments that coded for proteins. Myriad's patents effectively granted it the exclusive right to isolate a person's BRCA genes for testing and to create BRCA cDNA. Various doctors, patients, and advocacy groups, including the Association for Molecular Pathology, filed suit against Myriad, seeking a declaration that Myriad's patents for the isolated DNA sequences and cDNA were invalid. They argued that the sequences and cDNA weren't patentable inventions because they were products of nature. The district court held that the patents were invalid. The Federal Circuit reversed that holding, finding the patents valid, but affirmed the district court's decision in part on other grounds. The United States Supreme Court granted cert.